Hello everyone. Today we'll be discussing about contracts in case of private international law or conflict of laws, and uh, what is the rule of contract which has foreign elements in it, and how uh, the choice of law is determined in these cases. So contracts, what is a contract? We all know it is basically an agreement which is signed by the parties and it is enforceable by law. So in contract law, the issue of diversity crops up when a contract is entered into by entered in one state and its effect occurs in another state. So then what happens is the principle of conflict of laws is used to solve the problems that are generated in those contracts, such as international commercial contracts or transactions, or arbitration cases, insurance or property matters. So so who can be a party to such an agreement? The age, mental soundness, legal incapacities, all may be different in different countries or legal systems to which the contracting parties may belong. So the exchange of promise between parties to an agreement becomes binding and enforceable only by the virtue of the fact that the legal system of law declares it to be so. So when the parties are governed by the same system of law uh, in which they have made a contract, they do so in the knowledge that their actions have an ascertainable consequences under that law only. And when foreign elements are involved in the contracts, it becomes possible that a different system of law governs the contract or the party of the contract and confers a different set of rights and obligations on the party. So uh, in that case, the doctrine of lex loci contractus guides courts exercising diversity jurisdiction. It is generally used as a Latin term for law of the place where the contract is made. So, the law of the place where the contract was entered into should be applied to decide any issues arising out of that contract. Occasionally, the courts also use this phrase to mean the law by which a contract is to be governed. Okay, so this is one of the possible choice of law rules applied to cases testing the validity of the contract. Determining lex loci contractus. Sometimes it is difficult to determine lex loci celebrate contractus state. It is difficult to determine. The courts find it difficult to determine the place where the contract is signed. So this happens when the contract, for example, is signed at sea or on a moving train, or if the details of the contract signing were not well documented. So if the court is called upon to determine the applicable state, it may then use the the other factors, which are the residence or the main domicile of the signatory parties, the main place of business of the signatory parties, the state in which the business was incorporated, the state nominated for arbitration proceedings in case of conflict, the nation of registration of any ship, if any ship is involved in the contract, in performance of the contract, then and then the registration of the ship is considered. and the state where the completion of the contract is specified to occur. Thus, if similar contracts are signed by same parties, then that contract can also be seen to determine the choice of law that is given by the parties. So now what happens is some states have internal laws that restrict the application of lex loci contractus. For example, in Georgia, the application of foreign laws is limited to the statutes and the decisions construing those statutes. So, if the states restricts its public policy, then foreign law, then that will not be applied. So after this, the proper law of contract theory or test came. So until the 19th, mid 19th century, the courts applied the law of the place where the contract was made. It was open. So what happened was uh, it was open to abuse and at the same time produced difficulties in cases where the contract required each party to perform its obligation in a different state. So as a result, the English common law developed a test to determine which law will govern the contract, and that test was known as proper law of contract, and therefore the doctrine of proper law of contract emerged. Okay. So in proper law of contract, the parties were free to enter into whatever agreement for whatever choice of law they like. So in this rule, the system of law was known as proper law of contract. It was given by the parties in absence of choice. The reference uh, in absence of the choice, the parties had the power to select the law which was to govern their contract. So uh, the principle of party autonomy came into picture, where there is an express selection of proper law as to which law will govern their contract. So in this case, in this particular thing, the express choice of proper law came, and the which means that the conflict of law rules allow the parties to choose which law will govern their contract. The freedom this gave the party the freedom to choose their choice of law, and the freedom was however restricted by equitable principles. So what are equitable principles? These are public policy, good faith, the rules against abuse of other rights. The uh, express choice of law had two things. So first is party reference. In party reference, the parties submit their contract to the chosen law. They agree that all the disputes arising out of their contract will be governed by the law of a particular legal system. Okay, so they submit their contract to the a particular legal system, and according to that legal system their contract will be governed. In contrast, in under an incorporation, the parties merely incorporate certain um, legal provisions of a foreign law as the terms of the contract, by which their contract will be governed. A short It was a shorthand alternative to setting out in the contract the actual provisions of the foreign law. So this distinction in the conflict of law rules of United States, Germany, Switzerland, and Netherlands, these distinctions were found, but there is no indication that this distinction is recognized in Japan. In England, however, this distinction has been particularly relevant in determining the proper law in case of shipping contracts that make reference to the United States Act. Okay. Thus, if the parties are unable to agree on the law that is to govern all contract disputes, incorporation is one avenue for compromise whereby the most strongly desired provisions of one party's chosen legal system may apply. So after this, when there is no express choice of proper law, in other words, when where it has not been expressly chosen, the proper law depends upon the localization of the contract. The court imputes to the party an intention to stand by the legal system which has regard to the incidence of the connecting factors and of the circumstances generally. The contract appears most properly belong. So whichever legal system has the most substantial connection according to the connecting factors, that legal system will be considered as a proper law. So how substantial connection is seen? To determine the existence of substantial connection between a certain law and the contract, the following are relevant: the domicile and even the residence of the parties is seen, national character of incorporation, the place where the principal place of business is situated, the place where contract is made, and the place where